I've learned firsthand that the Supreme Court of Canada was correct when in 1989 they made this statement. Madame Justice Leroux-Dubé of the Supreme Court of Canada wrote that sexual assault is like no other crime. And they're right. Of all of the violent crimes that I've prosecuted, only victims of sexual assault ever come to me, even a year or more after the offense is against them, on the eve of trial, expressing their own self-doubt and their own self-blame. The media and the public get this wrong all the time. I can't tell you how many times that I've been talking in public, somebody finds out what I do for a living, and they make some kind of snide comment. One of my least favorites in the last couple of years was, I don't know what girls are thinking these days, the way that they dress. What I focus on is, I don't know what rapists are thinking these days. But even more importantly than those two factors is the ignorance that actual accused parties of sexual assault express on a regular basis. Either in court, when they're actually testifying about, if they're in court when they're actually testifying in their own defense, or when they're being interrogated by police officers because they are under arrest for suspicion of sexual assault. They make statements that are actually admissions of sexually assaultive behavior, statements regarding behavior that meets the definition of sexual assault. And yet when they are making those statements, they're actually professing their innocence. This is borne out. I have one statistic for you today, and that was a study from the Northeast United States of domestic violence offenders. These individuals were given lengthy questionnaires detailing what kinds of activities they had conducted within their intimate relationships. 54% of those offenders admitted to specific behavior that equated to the definition of sexual assault. 8% of them admitted to sexual assault. That degree of ignorance is a significant problem in our society, and it's actually a root cause of not just sexual assault, but the extremely poor response that we as a society, in healthcare, in law, and in personal relationships offer to victims of sexual assault. Ignorance of the law is no excuse. It's no excuse for offenders, and it's no excuse for any of us. Some of the things that accused have said in my own cases, I don't even have to go broadly to find these examples. Number one, that happens all of the time, would be, she didn't say no. That's an admission. She was drunk, but she wasn't passed out the whole time. Another good one, this is a direct quote from an individual who said, well, yeah, you could say we forced her, but it's not like it was a rape. And by all, my favorite of all accused statements is this one. Unfortunately, I didn't have it recorded. The police officer noted it in his notebook, so I'm just going to guess at the intonation. Yo, like a boss I was raping. I thought it was okay because we have kids together. You know that famous statement that we all hear on American TV? It applies in Canadian law as well. Everything you say can and will be used against you. Guess what? I did use those statements against those offenders, and they were convicted. I take no pleasure in that. That individuals were convicted of major sexual offenses based on their own ignorant behavior. So, here I am today trying to teach this small group of people Sex Law 101. Not all sexual activity is illegal, fortunately for us. But there are specific rules. All of us have legal rights and legal responsibilities when it comes to sex. And unlike any other crime, we as a society are ignorant of those things. So let's get started. Before we can even talk about sex assault, we have to understand what it is. Sexual assault is not defined by our criminal code. We have to take a step back and start with the definition of assault. Assault is the application of force to another person without their consent, or by threat of gesture that you are going to apply that force to that person. Even that definition should likely surprise any of you, because the second half of the definition means you don't even have to make contact with the other person to commit an assault. Did you know that? Most people don't. So a feigned punch would qualify as an assault. If I drove my vehicle at someone and missed them, that's an assault with a weapon. But we're going to narrow that use of the definition to this. Application of force, let's call that touching, okay? Touching without consent of the other person. To get to sexual assault, we add an extra element, and that is touching without consent of the other person that breaches their sexual integrity. Simple enough. That's the definition of sexual assault. Now, we all know that there's one key word that is constantly and regularly discussed when we're talking about sexual assault. And it's in the definition. It's consent, right? And there are a lot of catchphrases around that help us to understand what consent is. I'd say the number one of them that I've been hearing since I was a child is no means no, which is ridiculous. It is the most ridiculous misstatement of the law that I hear on a regular basis. Think about the consequences if that was actually the legal definition of consent. No means no. Does that mean we are all in a constant state of consent to sexual touching until we say no? Hi, my name's Avril, and by the way, whatever you're thinking, no. And until I've said that, you can do whatever you want. It'd be a constant race. You know, stick your hand down somebody's shirt and say, hey, oh, you didn't say no yet. Beat ya! That's not going to work, is it? So whatever you do today after listening to me, if you can force that thought of no means no out of your mind and recognize it as an archaic statement of something that was never the law, I'll have done my job. In fact, the media gets this so wrong that it's a case right out of Edmonton called Untitled that everybody talks about, the Supreme Court of Canada. It's their case where they said no means no. But I just told you that's not the law. What the Supreme Court of Canada said was that only yes is yes. And until there is consent, you're either committing reckless or criminal behavior. So consent is not something that exists in a gray area. It exists as a state of mind of the other party. And everybody's responsibility is to ensure that not only is that other party consenting to the sexual touching before the sexual touching, but that they have communicated that consent. Where does the responsibility lie? The person who wants the consent. It is not in the hands of the other party to communicate lack of consent. Consent is simply a matter of agreement to the specific sexual activity with the specific partners, I suppose, at a specific time. That's it. It's that simple. And it's your responsibility to ensure that you've received that consent. Now, there are limits. There are times when consent simply cannot legally be obtained. The number one limit, of course, would be age. In Canada, since May of 2008, the age at which a person can legally consent to sexual activity with anybody older than they are is 16. There are particular caveats, but if you are an adult and the person you want to have sexual contact with might be under 16, you also have that legal obligation to ensure that they are of a legal age to consent to sexual activity with you. And if you have any reason to think at all that that person is not of legal age to consent, it is your legal duty to inquire. And if you turn your mind and you don't want to know and you don't ask the questions, we call that willful blindness, and that's the same thing as having legal knowledge that that person could not legally consent to the sexual activity that you were pursuing. You cannot obtain consent, legal consent, through threats, either to the other person or to a third party. I hope that's well known. But you also can't obtain consent from a blackmail situation. Those phones that everybody carries now are a grave source of sexual misconduct. And I'm not going to go down that path today, but a very easy path for an individual to go down is if they have a gorgeous picture of their naked boyfriend on their phone. Boyfriend breaks up with them. They're so distraught, they tell boyfriend, I want you back, have sex with me. If you won't take me back, if you won't have sex with me, I'm sending this photo everywhere. That's extortion. That's blackmail. That sentence is actually higher than the sentence you'll get for the sexual assault if the boyfriend caves. Drunkenness? Drunkenness does exist in a gray area. There's a huge spectrum of impairment by drug or alcohol. One drink is not going to eliminate, likely, somebody's ability to consent to you. Drinking to unconsciousness, absolutely without question, eliminates their ability to consent to have sex with you. The issue is that middle ground. How drunk is too drunk to have sex? The courts don't know. They evaluate it on a case-specific basis. But somebody with significant sexual legal education, like you're all obtaining today, is going to know to be very careful. And if there's a time where you're concerned about the other party's level of inebriation and their ability to cognitively understand the sex acts that you're pursuing, it's best to err on the side of caution and take a step back. And finally, yesterday's consent doesn't count. Consent 1,000 times over the last 10 years is irrelevant. I know a sex crime educator here in the city who was giving a lecture to a group of judges. And a judge actually raised his hand and said, "You mean I have to ask my wife every time?" And she just nodded innocently and said, "Mm-hmm." Fortunately for us, consent can be conveyed through act or word. But you must understand the importance and the responsibility on your own shoulders to ensure that anybody you're engaging with is actually consenting and communicating that consent to you. Because you know what? The difference between rape and sex is consent. Related to issues of consent is the concept of provocation. Provocation is a complicated legal concept, and it relates to situations that have provoked an individual's emotional response to such a degree that their responsibility and their intent is mitigated. Most frequently, the concept of provocation applies in what would otherwise be a murder prosecution. Let's picture an individual comes home, finds his lover in bed with somebody else, and he stabs that somebody else. And that person dies. Frequently, a stabbing, especially to the chest or something, would be a second-degree murder charge. But the provocation of that specific incident might actually legally be considered to mitigate their state of mind and reduce their criminal responsibility. Guess what? There's no such thing as provocation to sexual assault. There is no action, there is no state of dress, and there is no behavior from another party that can remotely qualify as a provocation defense for sexual assault. It does not limit your requirement to obtain full consent from that other party. And full consent is required for every escalation of sexual activity. So if you've been engaging in some level of sexual activity, it's increasing in intensity, and then at some point, consent stops. No matter how much you are stimulated at that point, you don't have the legal defense of provocation if you continue after you no longer have consent. What I like to say about provocation is this, is that we all have the right to walk down the street naked and pole dance on parking meters, and that doesn't change anybody's right to touch us sexually except with our consent. And the reason provocation is a big issue, it is the source of almost every rape myth. And it is definitely the source of all internal victim blaming and outward victim blaming. Remember what I said? That dinner party where somebody said to me, "I don't know what girls are thinking these days, the way they dress." There's no such thing as provocation. Now, I was given 13 minutes to talk to you today about a topic that I've been studying and prosecuting for 10 years. So I've had to cut it very, very short. But one of the last things I want to dispel from all of your minds is the concept that rape and sexual assault is no big deal. Parliament and the courts recognize constantly the impact of sexual assault on the individual and upon society. Sexual assault is like no other crime, and the psychological impact suffered by sexual assault victims can extend throughout their lifetime. It is incumbent upon all of us to learn and to understand and recognize the seriousness of sexual assault. When we talk about the seriousness of sexual assault, in criminal law, the consequences for the offender are grave. Here in Alberta, the idea of sentencing sex offenders has been considered by our Court of Appeal repeatedly, and they've stated repeatedly that a major sexual assault should attract a significant sentence. What they mean by a major sexual assault is what anybody here would define as a rape. That is, intercourse without consent. And what they are talking about is that intercourse without consent with no other extraneous violence. No threats, no weapon, nothing. No prior criminal record of the offender. And what they say the appropriate starting point for that kind of offense is 3 years in jail. That is a federal penitentiary sentence. And when you get out of jail after you've served that federal penitentiary sentence, your DNA is going to be on the DNA databank forever, and you're going to be registered as a sex offender for 10 years, 20 years, or for life. And you are going to have that criminal record of a sexual assault on your record forever. That's why ignorance as a source of this kind of criminal conduct can't be tolerated. It must be stopped. Sexual assault is always going to be part of the human experience. Years ago, an individual who suffered the most significant and grievous sexual assault I've ever heard of, let alone prosecuted personally, when she was testifying in front of me in court, she said this: when the knifing stopped, when the cutting stopped, and she decided to stop resisting and just give in to the sexual assault, she said she told herself, women have been surviving rape for centuries. I can survive this. And she's right. Unfortunately, sexual assault will be part of the human experience for all women, for all men, and for all people. But if we can at least start intervening for the offenders who are offending out of damned ignorance, we will go a long way. And even more, out of getting rid of our own ignorance and understanding the true nature of what sexual assault is, we can avoid the constant victim blaming and provide a much more compassionate and understanding response. Thank you.